Welcome back. You are watching The Front Row. Now, in the last 1.5 years, the executive arm of government has lost all major cases brought before the law courts, questioning decisions and executive orders issued out by President Uhuru Kenyatta, from formulation of the Nairobi Metropolitan Services to the legality of the position of chief administrative secretaries, to the latest bombshell, one of course dropped by a 5-judge bench of the High Court on the BBI process, and of course the most recent being the case on Huduma number. And this has been put under sharp focus on exactly what legal advice they give the head of state, the office of course of the Attorney General. KTN's Timothy Otieno reports on a series of legal defeats by the president that is now sending an indictment on the office of the government's chief legal advisor. Let's take a look at that report before we get back to this conversation.
President Uhuru Kenyatta's string of legal battle defeats began in 2019 when, through the Attorney General's own advice, he rejected the appointment of 41 judges to the High Court. The president had integrity issues with some of them. The matter was taken to court, and despite 2 separate rulings in favor of the nominated judges and magistrates, the head of state is yet to pen the appointment.
We have seen Ouko, who was just, the name was forwarded yesterday, he's already been appointed.
Another perceived legal blunder by the president's legal advisors was witnessed when the courts poured cold water on the creation of the posts of chief administrative secretaries. The ruling suggested that 29 CASs sworn into office by the president in 2018 were appointed illegally. That same ruling by the courts questioned why second-term cabinet secretaries were serving without undergoing fresh vetting, something the AG should have pointed out to the head of state.
It is disaster for the office of the Attorney General. We never saw this during Professor Githu Muigai's tenure. We are seeing blunder after blunder.
Under Article 156 of the Constitution, the Attorney General's role includes promoting the rule of law and advising the president on legal matters, including assessing the legality of positions before creating them. That last role would come into sharp focus in June 2020, when the High Court once again criticized the creation of the Nairobi Metropolitan Services, a child born out of a ceremony which saw then Nairobi Governor Mike Sonko transfer some functions of the county to the national government. In a case in which the Attorney General was representing the government, the courts ruled that the transfer of functions was unconstitutional because the county assembly had not been involved. This decision would, however, be vacated by the same court in September last year. The string of legal downfalls shines a spotlight on the role the Attorney General is playing in advising the president.
How did it happen that the president can lose his judiciary, or in this case the High Court, so much that you can lose 99% of an important case? That's a big question that must be answered.
The recent indictment of the BBI process by the High Court only adds to a growing list of cases the country's chief lawyer is losing, putting to question whether or not he is offering any sound advice to the president, or his counsel is being ignored, or if simply the AG is misadvising the head of state.
People like the Attorney General who advises the presidency, don't expect them to give cogent and proper and independent view to their superiors. They will always tailor their opinions.
Since assuming office in March 2018, Paul Kariuki Kihara has been accused by critics of remaining aloof, especially when responding to issues involving his advice to the president. Whether the recent spat of legal flops at the courts will change his style remains to be seen. Timothy Otieno, KTN News.
Right, that story done by Timothy Otieno really touches on quite a number of issues that we've canvassed here, but we have about less than 10 minutes to go here on the show, and I'll get back to you, Martin. In that story, Timothy mentions that critics have also apportioned blame on the Attorney General. But also, some of the things that's also coming out from some of the responses we are getting, that are general feeling that the judiciary is now engaging in some form of judicial activism, like what you started by mentioning. Do you break that down for our viewers? What do you mean when you say that perhaps the judiciary is also overreaching, and how do we move this conversation forward?
Thank you, Akisa, for that. I think I want to use 2 or 3 examples to demonstrate that perhaps in its decisions, the judiciary has also overreached itself. For example, the judiciary has not questioned why the Attorney General, who also is the chief legal advisor to the government, sits in the Judicial Service Commission. Some have even said he should sit in the National Assembly, as the other one did. What would that mean? And again, when the judiciary says that the organization of government cannot include the judiciary in it, what is the understanding of the judiciary in terms of government being one, but with separate branches? The executive, the judiciary, and the legislature form one entity called government. So where is the coordination of that entity? There should be some coordination. There should be some leadership of that government, which then has 3 branches. So if you say that to put judicial commission under a ministry would be to say that you are actually undermining its independence, then where is the coordination of government? Where is the place for funding? Because remember, funding to different arms, including IEBC, comes from an arm of government, or rather within the executive, a ministry. In this case, the office of the Attorney General or Solicitor General. So there is some place where that allocation is made into budget and onto the commission. So coordination of government cannot in itself be an attempt to undermine the independence of offices. So that issue would be an issue that when you begin to look at it and you want to assume a separation of powers that can then create no interdependence, it is false. Just like, again, where is the national government and the county government intersecting? The Constitution says they are independent and interdependent. Similarly, the judiciary is independent of the executive and the legislature is independent of the executive, but they are interdependent to the extent that they go to the executive for facilitation and resource release. Now you can say, but this is money that's voted by people, but again, it's the National Assembly that votes. And that's why sometimes when the National Assembly comes against the judiciary and underfunds it, the judiciary complains. So what we are witnessing is that we are all uncomfortable with the arrangements that we have and are slow at looking for our intersections where we are interdependent, where the executive is interdependent to the judiciary, similarly to the legislature, and so on. So we need to have an understanding that the executive does not work in a vacuum. It is the representation of coordination of government, it being a 3-branch government, and therefore the judiciary and the legislature occasionally look to government, to look to the executive for certain services and certain facilitation.
Would you blame, Duncan, would you blame those who are accusing the government of, the judiciary rather, of judicial activism, looking at the decisions that they have made so far? Are they right to also apportion blame to the judiciary? Looking at the strained relationships these two arms have shared.
Looking at the strained relationship, I know there may be ground or room to say that maybe it's the judiciary getting back, but that position cannot be more wrong. The basis of that is because the structure that we have is that these particular chief magistrate or a magistrate can make a decision. You have room to appeal to a high court, to the Court of Appeal. From the high court, you can appeal to the Court of Appeal and to the apex court. To a large extent, you always have a second chance, and you find a different set of judges. So you cannot just say that just because a decision has been made, it is the judiciary overreaching. In actual sense, and I do disagree 100% with my colleague panelist, Martin, when he says that there should be such interdependence. The framers of this constitution, as adopted by ourselves, were very clear. When they wanted to say there is interdependence between the county government and the national government, they actually said it. It is in the constitution. When they said there should be separation of powers, because that is executive line, and even in the county government, there is still separation of powers. That's why we have the assembly and we have the executive side. When we come to the national government, it is actually important for us to ensure that there is proper independence of the judiciary, because the judiciary is the only arm that can actually check both the legislature and the executive. And in many democracies, and even historically, it is the executive that always has excesses to a point that they actually affect the common monarchy. The judiciary is actually there to protect and to guard against this. And we saw it in this country after the 2017 elections.
Yes.
When we were told that indeed there will be some revisiting. And Maraga's tenure from there became actually a very sad affair. And why? Because he could not be given funds. Even what people thought were and referred to as petty issues of the vehicles and all that, to a point that he said, I cannot even attend any other national ceremony in my capacity. It is so serious as such, so that if the Chief Justice can be frustrated by the judiciary, by the executive, what about a mere judge? What about a mere magistrate? What about a mere tribunal member? It then means that, and if they are frustrated, they are being frustrated because of my case, your case, and someone else's case. So that tomorrow if I have a claim, and even if my colleague Martin will have a claim against any government agency, I can assure him that if that is a position he takes, that particular judge that will be filing a case before will not have the powers.
All right.
So it is important for us to look at it in that perspective and not to criticize them, because ideally these rulings are there, they're in the open.
Yeah.
The reasoning is there. The logic is there. They do not just give a decision as a carte blanche.
So we're out of time. I'll give you about a minute. What would be the best way forward? How can the government come back from this, the executive especially?
Professor Githu Muigai did resign, so it's not unheard of that someone can resign from the same position. The current occupier of this seat is none other than a former president of the Court of Appeal. So much is expected from him. But the buck, I do say, stops with the president, because he is the client. It is the client that gives instructions. It is the client that decides that, no, I need to make any changes. The courts, as I've said, must then decide that if changes do not come, people must pay for coins or shillings or millions of shillings that are appropriated without subjecting those decisions to constitutional standards, because we are paying people to actually do their day-to-day work in ensuring that constitutional standards are met.
We have about a minute to go. Martin, perhaps get your closing remarks. How do we sort this out? How do we fill in the gaps?
I go back to the point I said, which Duncan says he disagreed with, but I want to re-emphasize it. There's a difference between the independence of the judiciary in its decision-making, where even the magistrate is independent from the judge, where the judge is independent from the Court of Appeal, and where all judges are independent from the Chief Justice. Similarly, there is the independence of the legislature as it performs its legislative function, because that is its mandate. And similarly, the executive has independence as it forms its executive mandate. However, when it comes to the coordination of government, which has 3 branches, all those branches are interdependent of each other. One will generate proposals for legislation, the other will pass in terms of the National Assembly, and the other will enforce it.
Right.
So basically what we are saying is that we just need to learn our basics and live by our basics.
Okay. Thank you very much. What a way to end the conversation. Martin Olo is an advocate of the High Court as well as a political analyst. So is Duncan Okache with me in studio, an advocate of the High Court. Gentlemen, thank you for joining us and just helping Kenyans break down some of these issues, getting to the crux of the matters and coming up with giving perhaps a way forwards. We hope that some of it will be adhered to if the powers that be are listening to the show tonight. But thank you for joining us. I am Akisa Andera. I'll see you again next Tuesday on Front Row, but tomorrow night, or rather Thursday night, we'll be on Crossfire. So I'll be seeing you then. Keep it KTN News. KTN Prime comes up next.